and children, file number 23119.
All right, counselors, welcome back.
Thank you, Your Honor. At this time, the department is not ready to, dismiss this petition. If we were to do so, there would be no tracking of the criminal case or any ongoing services for the children. We are obviously continuing to be agreeable to any adjournments to match the timelines of the criminal case or state the proceedings.
Ms. Heiss.
Also with the sidebar, my colleagues were not opposed to some case planning, and I would like this case to not be dismissed because I'd like this case, the criminal case, the idea of a custody case, all to be in place so that if any solution serves the child and the family best, we can choose among the services available in any of those. And towards that end, I would ask you to schedule a review in May or June so that, and the other thing that I was worried about if dismissal is I'm not sure which services would be available to this family on their private insurance. And I'd just like at least time to look into that. I know that they're seeing Ms. Abbott, who used to be through the CAC, and I'm not sure which resources are available through private insurance. So anyway, I err on the side of not dismissing at this time. The bond conditions, as you know, there had been a motion to change the bond conditions, and I would anticipate that there could be more. So I don't know that those bond conditions are sufficient to protect the children.
Well, I don't have technical admission of these exhibits yet, but I have reviewed them. And it looks like the oldest child has been discharged from therapeutic interventions at CAC and is just engaging in maintenance therapy. I don't have an update for any interventions that are in place for the other child. That child was in therapy at the CAC, but I don't know what interventions are in place beyond that. Or I'm sorry, at Catholic Charities. So as far as ongoing services, from the first proposed court report to the second, it would appear all three family members, mother and both children, were engaged in therapy in September. But as of this court report, the only update I have as it relates to that is on the oldest child. So and she's graduated from CAC therapeutic interventions and the family is identified a desire to engage in maintenance therapy. So I guess I'll look forward to any additional testimony on what ongoing services we would need, frankly.
I just want to clarify, the report we have for today's hearing is related to the youngest child.
Okay, yeah, we have no reports on the other child.
Well, the first one in September addressed the mother and both children.
Right, that is correct, Your Honor. But for today's court report, there are no therapeutic updates beyond the letter discharging the youngest child.
Right, that's what I just articulated, and that's why I, the argument. Make sure that, everybody on Zoom is muted. So that's why I'm saying, I don't know what the ongoing services are that would justify the need for the department to be continued to be involved. But I guess, do you want to take any testimony on your court reports today?
Yes, Your Honor. Mr. Farian, can you swear in?
Mr. Farian, come on up.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God? I do.
Good morning, Mr. Farian.
Morning.
Today we are going to be looking at two court reports. So the first court report was submitted on September 25th, 2023, and then the second court report was submitted for today's hearing on 12/4/23. Are you familiar with those court reports?
I am, yes.
And you draft those, correct?
Correct, yes.
To the best of your knowledge, let me go back. The one that was submitted in September includes the CTAC report for M. Mulholland the council recommendation for M. Mulholland,
Correct.
then the B. Mulholland CTEC report, and then B. Mulholland's council recommendation letter, correct?
Correct.
And then in addition to some ICWA documentation.
I'm sorry.
In addition, there was some ICWA documentation.
Correct, yes.
And then for today's court report, there is a court report and then I believe a letter discharging M. Mulholland. And that is all that we have, is that correct?
Correct, yes. It's my understanding, well, the service provider, Ms. Abbott from Catholic Charities, has discharged Blake. At the time when I had made contact with her, she was dealing with a family emergency, so I was not able to get anything necessarily in writing. And then, as indicated, I think by the exhibit or the attachment that I put in there, that she is seeing M. Mulholland on a maintenance level. So, and it's my understanding, I think, and I got some of that information after I had already submitted the report, that she's seen her twice and then scheduled again, I believe maybe today. And it's a bi-weekly type maintenance.
Okay. Do you happen to know if that's also occurring for the oldest child, B?
At this time, services were, is my understanding, are no longer needed for him. But again, I haven't gotten that in a letter format that I would feel comfortable submitting to the court.
Okay. And this case, we have asked the court not to require us to provide reasonable efforts, correct?
Correct.
But what are some of the services that the department does offer the family?
Currently, from right now, case management, when there's been, if there's been any issues or the mother knows that she can contact me if she's having financial issues, you know, taking care of anything related to school related, obviously the holidays are coming up, anything that would go with that. Resources in terms of just referrals to other places. I know we've discussed, because there were some issues with insurance. I think that, as Ms. Heiss had indicated a few moments ago, regarding what counselors and other services that we could provide at that point in time. As of right now, I've kind of been everything's been going well with their counseling, so we haven't pushed too much else at this right now.
And during this, I guess, since we've been to court last and from the dates of the prior court report, has there been any changes for the department to reconsider their position on the petition as relates to Mr. Mulholland?
No, not at this time. It's my understanding, or it's not my understanding, we still have the allegations that are in place. They're still being prosecuted through circuit court now. So policy and or child protection law indicates that this is a termination trial.
Thank you. And do you believe that there's still the risk part of the children were to be, I guess, released to their father's care and custody?
I've had very little contact with Mr. Mulholland in terms of services or anything. I have been working through his attorney, and she has provided me some documentation that I was able to get today. But as of now, I've not been able to have like a family team meeting or anything like that to, you know, discuss what necessarily is going on. So in his life.
So is it your opinion that the conditions that caused the petition have not been addressed or remedied?
To my knowledge, no.
Is there anything that you'd like to bring to the court's attention for purposes of review and letting the court know how the children are doing or where things stand with the case?
So as of right now, yes, that answers your question, yes. So as of right now, they're doing well in school. Both of them are attending school regularly. In the conversations with them and mother being present. They seem to be liking school. I know that the youngest is playing basketball right now, so there's some extracurricular stuff going on. The B Mulholland will be starting soccer in the spring again. They seem happy, they seem healthy, they've got family support. So as of right now, I think that they're doing well.
Thank you. There are no further questions of this witness, and move to admit the court reports that were submitted in September 23 and then for today's hearing.
Any objections?
I have no objection.
I have received and reviewed them. I have no objections.
Thank you. They are received as evidence. I have a total of effectively eight exhibits, including the court report. Do you have cross-examination questions, Ms. Hanson?
Yes, I do. Mr. Farian, in the information that I provided to you, they included AA attendance sheets on behalf of Mr. Mulholland, is that correct?
Correct, yes, I just received those today.
Okay, and I also indicated to you that we would be willing to meet with you via Zoom if I was allowed to participate, is that correct?
Correct, yes.
Okay, and that was right around the Thanksgiving timeframe, so we were unable to schedule, is that
Yeah.
correct?
I believe that the date on that email is the 28th of November, so it would have been Tuesday after Thanksgiving.
And you submit and draft your report 1 week ahead of today's hearing, is that correct?
Correct, yes.
Okay, and I also brought to your attention that my client is participating in individual counseling, is that correct?
Yes, but I was not able to verify, nor I didn't know where he was.
Okay, how would you verify?
Well, I was hoping that we would sit down to do that family team meeting and we could discuss some of the different things that he's doing. I've asked Mr. Mulholland in the past what services he's doing, and I was referred to you at that point.
So again, I will ask you, how would you like that verified? Would you like a letter from the counselor?
That would be perfect, excellent, yes.
Do you understand that my client is hesitant to offer you any release and you're not asking for a release of information, is that correct?
I would prefer a release of information, but if he's not choosing to do that and he would like me to submit and put those things in my report, yes, I would like a letter that at least verifies he's attending.
Okay. Also, is there any reason for you to verify his employment at this point in time in the case? Would there be any reason for that?
Other than just to report that he's employed and he's able to provide for his children, no. Other than that,
But the department's position at this time is that you don't want him to be around his children or to actually continue to parent his children. So what would be the necessity of that?
it would be voluntary.
Okay. Same for housing. You're not looking to return the children into his home at this point in time. Is that correct?
That is correct.
Okay, so where or when he's not exercising any parenting time in his home, nor would he be able to, at this point in time in the case, receive the children back into his care. Is that correct?
Correct.
Okay, so verifying his housing with you is not really necessary either.
The only reason that I would like to do that is to update the system in case with an address, so that and then if we were in need to find him for any other reason or in the future, that we would have that address.
Okay, I've provided you with my office's address for any and all mailing and any and all communication. Is that correct?
Correct, yes, and I've documented that. Yes.
Okay, thank you. Have you talked to the mother in this case on the fact that Mr. Mulholland is providing financial support to the children?
I had asked that previous, I don't know that I asked that on my last visit that he was providing any service. I had asked a general question, do we have anything, do you need anything, or are all your bills being paid, those kind of things. Directly, did I ask, is Mr. Mulholland giving you any money? I did not ask that question.
Okay. Did Ms. Mulholland indicate that the children were in need of anything financially or any other way? She
did not.
Okay. So in your knowledge and experience, how long have you been a caseworker for the department?
As an ongoing or just in CPS in general?
CPS in general.
10 years.
Okay. In your experience, is 6 months of biweekly counseling, is that a typical range for children who've experienced the trauma that the department is alleging that they've experienced?
I think that's subjective, depending on what the counselor and the child or the victim, or however you would like to put it, needed. I believe, well, I guess, so that would be my answer for that. However, if you're referring to,
Nope, I'm just referring to what I asked you. In your knowledge and experience, is there cases where children are in counseling for many years?
yes,
Are there, is 6 months in your knowledge and experience, is 6 months a pretty short period of time if we are not seeing children, but maybe for 19 visits in those 6 months?
again, I think it depends on,
I'm asking in the
I don't have an
entirety of the
opinion on
case.
that then. And yes, I don't have an opinion on that. I can't answer that question.
Is it common in the cases of this nature for children to be in counseling for a much longer period of time than 6 months or 19 visits? In your knowledge and experience?
Yes.
Thank you. Is there, if you were to check on my client's compliance with his pretrial services for a circuit court case, do you need a release for that? Or are you able to just communicate with pretrial service engagement officer?
If I could know who the officer is directly, that would kind of circumvent the system, but yes, I can go through that and find that information out.
Darren Coast, are you familiar with Darren Coast?
I do know who Mr. Coast is, yes.
Okay. He is the felony pretrial service officer. So would that provide you with the information that you need to verify PBTs, drug screening if it's applicable, and general compliance with conditions for small town?
Yes.
Is the department currently paying for therapy for the children?
We are not. There's private insurance involved.
Okay. Did you refer them to Catholic Charities?
Those things were done prior to me being involved in the case
Do
personally.
you know from your case management software if those referrals were made prior to your involvement? Were they made by the Department of Health and Human Services?
I do not know the answer to that question, only because they originally gone through the Child Advocacy Center, which I believe is attached to Catholic Charities.
Is the Department of Health and Human Services affiliated with the Child Advocacy Center at all?
That's just the local place that we use in terms of getting forensic interviews done. That's our interaction with them. I don't know of any other way that that's done. So.
Okay, thank you. In the next reporting period, what would you like to see from Mr. Mulholland?
Again, it's all voluntary, whatever. I would like to sit down and maybe find out what he's willing or not willing to do. I have gotten now a list of kind of the things that he is doing. So if he feels like he would need any other services at that point in time, I would be open to listening to what he needs and make a referral or do what needs to be done.
Based on what I've presented to you and the fact that he is in individual counseling, he is in AA, he is addressing his bond conditions, address monitoring for substances. At this point in time, what services would you recommend?
I don't have any more further recommendation, and based off of the information you give me, he's employed, he's got a lot on his plate, and it sounds like he's doing a lot of great things. So again, it would be more of, does he feel like he needs something else, or if there's anything else, even with his bond conditions, if there was a service that they were recommending or requesting that he do, I would be more than happy to help facilitate him getting those as well.
Did you participate in his bond hearing in circuit court on October 7th?
I don't know.
Okay, were you asked to?
I believe so, no.
Okay, thank you. I have nothing further.
Ms. Weiss?
I have nothing further, thank you.
Okay. In the trauma assessment for the older child, there's a referral to a 8-week group course potentially hosted by DHHS and CMH offices. It's a curriculum parenting children who've experienced trauma workshop. Were you able to look into that for this parent?
I do not, no, I wasn't aware of that. Which child are you referring to? Or
I
is
think
it
it's
just in
actually
general?
in both assessments. It's a referral for the parent or caregiver of a child.
No, I was not, but I would be more than happy to look into that. So it's something still needs to be done.
Yes,
Requested.
it's in both recommendations.
Okay, perfect. Yes, there was, I think some of those things, the way that those were done and when those were done, there was kind of a crossover in between workers, so that if it was on I missed that, so.
Okay, there's also a referral for the oldest child to have an occupational therapy evaluation. Do you know if that's been done?
I'm not under the impression that there are any special needs indicated for this young man, so. I don't believe that that's been done through the school or any of, I would assume that the school or somebody would have done that, but I was not aware of any special needs.
Okay, yeah, that's in the recommendation for the oldest child is number 4.
Okay, I will look into that as well.
Okay. Are there any services that your department is paying for or providing to the family right now?
Not currently, no.
Is the monitoring, the case management monitoring that you're doing effectively just seeing what happens with the criminal case and then obviously being available to the family as you described?
At, and what we would be doing here, yes, as well, reporting to this court.
Okay, very good. Any of that, would that be able to continue without the formal jurisdiction of the court through the department?
No, we're not. We would close our case.
Okay. Any questions based on my questions?
Just one, Your Honor. So they wouldn't qualify for it as an ongoing case or any of those preventative services?
No, because I mean, I would have to look into the prevention aspect of it. However, I do not believe that they would qualify for it because I do not have somebody who necessarily, the ongoing part, there is, the children would be deemed safe. They're with mom, there's, you know, certain things in place at the moment, but as we discussed before, we don't know how long those would last or if they would continue. And then as a prevention case, those are newer to me, and so I'm not sure. Usually that's more for younger children, you know. So.
Okay, thank you. I don't have anything further.
I have no redirect, Your Honor.
Ms. Hanson-Grimes, any recross?
At this point in time, if you're not monitoring the case, and the bond conditions from circuit court remain in place, what are you doing?
I answered that question.
Well, okay. So what would be the purpose though, if you're not monitoring, like if the bond conditions remain in place and the criminal case plays out however it plays out, at this point in time, if you're not paying for services and the family is not asking for any other services and they're not, what is the department doing? You stated that you're a little unfamiliar with preventative cases at this point because they're new to you. What preventative measures could you offer or are you be willing to offer?
So here's the thing about the way prevention is done in our office. It's a voluntary service, right? It's more or less voluntary. I just can't open a prevention case and say, hey, you gotta do this. So it's voluntary at that time. That's the difference basically between a prevention case and a regular case. So I wouldn't be able to offer it. I don't know what services I would do with prevention. A lot of times prevention is due to things like, you know, just financial burdens, sometimes, you know, just helping meet different barriers for families at this point in time. Are there a lot of barriers right now with this family? No. If that's what, there aren't barriers right now. They've got things managed. So I wouldn't necessarily be doing a prevention case.
You've requested in your relief in your court report that you not be required to provide any efforts to Mr. Mulholland, is that correct?
We're not required to offer efforts.
But you've asked for an order for that to continue, is that correct?
Yes.
Okay, so we're not providing any services to the family because they don't need us. And we're not willing, or we don't want to provide any services to dad, so he's taking them upon himself voluntarily. So really at this point, what is the department's place in this?
It is to, again, that was stated, if we close our case, there's no check or balance if something were to change within the criminal court, right? It would require us,
So if something were to change, like what?
bond conditions get dropped, reduced, whatever it may be, for visits and of things of that nature. We wouldn't have the ability to monitor that stuff. Only because it would require us to have a new investigation in order to go back in.
So if something were to change in the criminal system, such as an acquittal or the bond conditions were reassessed because the risk of harm was undoubtedly not there, you would have to reinvestigate to see if there was a substantial risk of harm between this parent and child, and you don't want to do that because you want to rely on the past.
I'm not exactly sure what you're asking.
So you had just stated that if any of those conditions were to change, there would have to be a new investigation if the case was dismissed. Is that correct?
Correct.
Okay, and so at that point in time, and you were a CPS investigator for many years, is that correct?
Several, yes.
Okay, so if a new call came out that the bond conditions or an acquittal occurs, then a call would need to come into CPS, and then an investigation would need to find a risk of harm between Mr. Mulholland and his children that would prevent contact between him and his children, or to have a petition filed with this court. Is that correct?
Can you simplify that? Because you just said a lot, and I think that what I really want to answer is in the tail end of that, so.
Answer what you want and I'll redirect you.
I think. I don't know how to answer that. I mean, I'm very confused by your question.
Okay,
So,
I'll rephrase it.
Thank you.
If the case is dismissed as of right now.
Correct.
Okay. And there were changes, and I'm assuming you mean changes to bond conditions or changes in the fact that the criminal proceedings are no longer proceeding. Is that correct?
Correct.
Okay. That there would need to be a new investigation by CPS. So there would have to be allegations of harm to the children by this parent. Is that correct?
Okay, so I still think there's a couple different layers on there. The allegations from the original petition would still be there. Right, we agree upon that? I mean, so I'm thinking also that we still would have our risk of harm. And on top of that is, we don't need the criminal case to go through in order to still file our petition for termination. The bond, what you're referring to, in my understanding, and I guess, is it okay if I ask a question? To a clarifying question, is that okay with you?
I'm okay with the question. Yes.
It's your
Okay.
cross-example.
Yeah, I mean, I guess, right now, the bond conditions are part of the protection of the children, right? So the bond conditions in the criminal court.
Correct.
So we still have our thought that because of the nature of the allegations, that it would still be inappropriate for contact between him and his children.
But you stated that your only function at this point in time is to monitor the case. So if that case goes away,
We would still have to revisit where it is in this court, yes. Because I guess I'm not following, because what the criminal, we've dealt with, we all have been in these cases before. What happens in the criminal doesn't always have to play in what happens in this court. They're two different courts. They're two different burden of proof. There's a preponderance of evidence versus beyond a reasonable doubt, correct? So.
And don't forget our good friend clear and convincing.
Yes,
evidence,
that's
too.
true. Okay. So, I mean, I guess that's kind of what I'm saying. Based off the information, based off of the police reports, based off of everything that I have, yes, there is still a reason that we should be in this court.
Thank you. I have nothing further now.
Okay.
Oh, hang on, I do. May I get, I presented you with some AA sheets today.
Yeah.
When you get back to your seat, will you present them back to me so that I can admit them to
Absolutely,
the court?
yes.
Thank you. Nothing further now, Your Honor.
Thank you for your testimony. You may return to your seat. Any other witnesses?
No, Your Honor.
Anyone you'd like us to hear from today, Ms. Hanson Grimes?
Yes, Miss Erin Abbott.
Thanks. Stand.
You swear or affirm to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Proceed.
Your name for the record.
Erin Abbott.
Thank you.
Okay, Miss Abbott. You are a counselor to M. Mulholland and B. Mulholland, as they are referred to in this case. Is that correct?
Correct.
Okay. And you did not provide a report to Mr. Ferry today. Is that correct?
Today, no.
Okay. No, not today,
Oh.
not last week, not this reporting period for the last 90 days. Is that correct?
September, I think, was the last one.
Okay. Why is that?
I've been on medical the last week or so with a family emergency. And I don't have any request for a report.
Okay. So the children are doing well?
So under confidentiality of my license, I cannot discuss anything with counseling. My notes were not subpoenaed, nothing was subpoenaed. So actually that's all client confidential information.
We do have your notes from the trauma assessment. We do have your
That's
notes from the
separate
last.
for me. So I work as a counselor, as a licensed professional counselor, and then I also do trauma assessments. I still have the same license. So only thing I can answer are for the trauma assessment. I cannot answer anything specific for counseling.
So when you write letters as a counselor to the court or to the circuit court, you are able to write those letters?
I'm able to say when I start them, when I start services, when I end services, and I can't give any specifics on what the children say. I can't say B said this or M said this. I don't give any specifics for confidentiality reasons.
But you do get recommendations.
I recommend, the only one recommendation I gave was that the children should not start visits until after the criminal case.
Wasn't the children, it was B. Mulholland specifically.
At that time, I was not seeing M.
Okay, when did you start seeing him?
I'm not sure, I don't have my notes in front of me.
Could you give us a month? Was it after you wrote the letter? So
I
it was
don't
in
know,
October?
I don't know, because I didn't know what I was being subpoenaed for, whether it was CTAC. or
You're being
counseling.
subpoenaed for your testimony.
Yeah, I don't know, I can't tell you that date.
What made you write the letter to say that you did in fact have a recommendation regarding parenting time in the circuit court bond hearing?
For B.
Yeah.
For B, things that have been said to me in counseling.
Previous to that, you wrote a letter saying that you didn't have enough information.
Correct.
Okay, because you had not viewed the parent and child together and you weren't going to make a recommendation. Do you remember writing that letter?
So if you want to show it to me, so I mean, I write a lot of letters, this has been going on for quite a while. So I don't know specifically.
Are you still seeing B as a patient?
He's discharged,
He was discharged? Maximum benefit received,
met his goals.
met his goals? May I approach you? You may. Okay, this is labeled Exhibit D from the department from the, I think, September 25th court report. Do you remember writing that letter?
Yes,
okay? And you took the stance of not recommending anything regarding parenting time because you had not viewed parent and child together, is that correct?
because I do not see them as a unit.
Right.
Correct.
And you said that you don't provide reunification services. You've stated that in previous reports, is that correct?
Correct.
And that you don't provide family counseling.
Correct.
And so the possibility that you would have seen them as a unit would have been when, during the trauma assessment?
I did not see Mr. Mulholland at the trauma.
No.
assessment.
I'm asking you, like what you said that you had never seen them as a unit, but you don't provide that service. So when would you have seen them
During
as
the
a
trauma
unit?
assessment. But
Okay,
if not,
but you also felt compelled to interject into the circuit court bond hearing. Were you called to testify there?
which one was that? I was asked to testify another one, but I had like a 12-hour notice, so I didn't show.
By the Lenawee County Prosecutor's Office, were you asked to testify or were you only asked to write a letter?
Just to write a letter.
Okay, and so why, without meeting with Mr. Mulholland, without meeting with him and the child together, why would you then take the stance that no contact should be allowed?
So this letter says I cannot make a recommendation because I do not see him and his father together.
But several weeks later, you made a recommendation on behalf of the Lenawee County prosecutors, is that correct?
Not on behalf, on what I've heard in therapy.
But you can't tell us, or you won't
Correct.
tell us what you've
I
heard. in
can't, it's
therapy.
confidential for my license.
So you gave no basis, but you took a stance that was completely contrary to the stance here.
It's not.
Who asked you to do that?
They just asked for I'm not even sure if it was the prosecutor or CPS for a report, that they always do for a report on whether I'm seeing the child or not.
And you're saying nobody specifically asked you to talk about parenting time with Mr. Mulholland?
On this one, they said, can you make a recommendation? And that's why I said I cannot make a recommendation.
On the other one, did they ask you for a recommendation or did they ask you to shut down the recommendation that an assessment be had?
First of all, nobody asked me to shut down anything, but could I see the letter that you're referring to?
No,
Then I can't answer to it.
you don't remember making a recommendation to the circuit court on behalf of the prosecutor stating that reunification therapy should not occur.
If you cannot show me the letter, then I cannot speak to it.
So you routinely just draft letters and don't remember drafting them?
I draft a lot of letters. I have a lot of caseloads. I do trauma assessments. I do a lot of different things, so I don't want to misspeak.
Did you participate in the interventions? When you make the recommendations from the trauma assessment, do you participate in those? Like, are the recommendations at your development?
Yes, we as a team put them together.
Okay. Are you actively working with the Lenawee County prosecutor in the criminal case?
No.
Have you ever been consulted about M's ability to testify?
No.
Okay, but you did make recommendations regarding that in your trauma assessment, is that correct?
So what did I write in my trauma assessment? I think that was done about 8 months ago, so I would have to have a review.
Okay, you'd stated Morgan or M does not appear to be stable enough to testify due to emotional dysregulation about her father. If a 10-year approach is available, it would be in her best interest.
Yes, and that was dated what? Could you just remind me? I know it was a while ago.
8/21. Okay, so that was true in 8/21. Do you believe that is true today?
So when I wrote that, I was only saw her for the trauma assessment date, and so that would be true on the, as of yes, or on 8/21.
Okay, would it be true today?
I don't have an opinion on it. Or M.
How do you not have an opinion on it?
Lack of time with the child.
But she's discharged now,
No, she's not.
not from your service. So you saw her in both capacities. You saw her in your capacity at the trauma assessment and in your work with the CAC, and then in your own private practice.
No, I did not see her with the CAC at all.
So who do you perform the trauma assessments through?
The Child Trauma Assessment Center, we're a program of Catholic Charities.
What are your thoughts on the participating in the assessment with his father today?
I don't have any thoughts on it.
Well, you had thoughts several weeks ago, and now you're no longer seeing him because his goals have been met, so you don't have any
Are
thoughts.
you talking about B now?
I said B, yeah. You don't have any thoughts
Well, I
regarding
already
that.
completed the trauma assessment, so it's done.
That's not what I asked you.
I don't do family therapy.
Again, not what I asked you. I'm asking you, what are your thoughts as a therapeutic provider who has now discharged their patient regarding contact between B and his father?
I don't have an opinion on that right now. I don't have an opinion when I discharged him.
So your lack of an opinion is again a change from the recommendation that you made in October stating that there should be no contact.
So again, I would have to review all my notes. I have multiple clients, multiple notes. And again, I can't dissolve what's in the notes because my license and confidentiality.
I'm asking why you now state that you have no opinion where you had expressed, let's just go back on the timeline. In August, you expressed an opinion.
Professional recommendation that the children did not see him. I don't know that. I don't do unit therapy. And he's up for sexual abuse. And that's not been dissolved yet.
So in your letter that I presented to you, you said that you could not make a recommendation.
Yep, on August 22nd.
Then on October 7th,
I don't know. I don't know what that letter says. I'd have to see it again.
do you routinely write letters that contradict other letters?
Again, I don't know what the October 7th letter says exactly. I would have to see it to speak to it.
And you don't remember who asked you to write that letter?
I'm not looking at my notes now.
And you have no opinion based on your client being discharged? You have no opinion, so you don't have a forthright opinion like you had on October 7th.
I don't know what I would need to see my October 7th.
Your October 7th letter stated that you did not recommend contact between V and his father until the criminal proceedings went through. Okay. You actually termed the word reunification, which is nowhere where we're at in this case.
I'm not a lawyer. That's what, in my words, when parents and children come back together, it's reunification.
So you're stating now that you've completed counseling with him, that you have absolutely no thoughts on this whatsoever.
Not without reviewing notes and.
Okay, you saw the name of the case when I subpoenaed you, correct?
Right.
You didn't take an opportunity to review your notes?
I called you because again, I have two different roles. I have the trauma assessment center and I have therapy, and I never received a call back from your office to clarify what I was being subpoenaed for.
You were subpoenaed to testify, so you didn't review any of your notes regarding this case whatsoever.
I did review, but I didn't know which one I was reviewing, CTAC or therapy. And again, I can't divulge anything with therapy due to confidentiality.
If the bond conditions were relaxed in order to allow for assessment between B and his father, would you interject in that hearing again?
I have no opinion.
You have no opinion.
I don't see B anymore in therapy. I don't know how he's doing today.
Okay, so you agree that you would have no right to speak on B's behalf
As
in
of
any
right now,
further, at today's hearing or any further hearings?
as long as he's not my client, going forward, I have no idea how he's doing.
Has the family asked to retain your services any further?
I see, still,
Okay, and how often do you see them?
she is bi-weekly.
Okay, and that's for maintenance therapy, is that correct?
Correct, she completed trauma therapy with the previous therapist.
And this, in your, how long have you been a therapist?
6 years, 7 years,
Okay, and has your clientele been primarily children?
yes.
Okay. Is 19 sessions usually adequate trauma therapy
19 sessions for who?
for M?
I did not do therapy with them for the trauma therapy, so I can't speak on that.
Do you provide trauma therapy?
I do.
Okay, why did you not do therapy with them?
She referred to the other therapist. There was 2 of us at the time.
Is there 2 of you still in your office?
I'm not at the Child Advocacy Center anymore.
When did you leave there?
June, I went from one program. I'm still at Catholic Charities. And now at Catholic Charities is doing outpatient.
Okay, Ms. Hanson, guys, we have 5 minutes until we know.
You said you left in June, but completed an assessment. Oh, you completed the assessment through Catholic Charities. Okay, and I have nothing further for this witness, but I would ask the court to, any ongoing hearings that we may have, that her subpoena be considered valid and that she received notification, not just a process served subpoena as she ignored my previous one. So I would ask you to continue her subpoena to any ongoing hearings, Your Honor.
I will take that under advisement. Do you have any questions for this witness, counselors?
Just one. When there's a CTAC evaluation and then you see a child for counseling, do you as his counselor have access to the CTAC recommendations?
I do.
And do you incorporate the recommendations into the counseling goals?
Yes, I mean, yeah.
Thank you. It was an assumption I wanted to check. Thank you.
Okay, thank you for your testimony. May return your seat. You can just leave. Okay, thank you. All right, ladies, we're at the noon hour. Do you need to continue this hearing to a different day, or would you like to comment and close out for today?
I just have a couple of exhibits that I would like to admit, and then if we end up closing out, then they're admitted for today. They are what Mr. Farian testified to as it relates to AA sheets and an email go between myself and him going on about what services my client is voluntarily participating in. Do you have any objection?
I have none. I have
So
reviewed
this
them.
would be respondent exhibit 1 and 2.
I have received them. Email and then AANA sheets. Okay, comments?
Thank you, Your Honor. We would just ask that this court continue the current holding pattern that we're in right now, and schedule this for after the criminal case. I know that there's some discussion about what is the purpose of CPS being involved. And ultimately, we are relying on our statutes that an allegation of this nature, including the sexual assault upon a child by a parent, does require us to file this petition. It does require us to ask for the termination initial disposition. We are in agreement that there are safeguards in place that need to continue to be monitored in order for the child to remain safe. And therefore, we are asking that we remain on the case and that the case not be dismissed at this time. So with that, we would ask for that 6-month review as the children are with a non-respondent parent. And we will continue to monitor the criminal case to see how that will influence our trial moving forward. Thank you.
Ms. Hanson,
Quite frankly, Your Honor, I think the statements on behalf of the department that state that all they're doing is monitoring and not providing any real services speaks for itself. I think that if the criminal case resolves in a way where it would be necessary for them to reissue this filing, that it could very well be dismissed at this point without prejudice, and then be refiled should the circumstances find themselves that the children would be at a substantial risk of harm if permitted contact with my client. We do not believe that is so today. In fact, we ask that you continue your recommendations so that we may be able to seek relief from the circuit court as it relates to whether or not a bonding assessment and a assessment regarding whether contact would be traumatic to the children, or at least in the case of B. At this point in time, I think that all services that are going to be in place are in place. My client has taken in his own volition to participate in services. The department's not helping him, and they've actually requested not to help him. So at this point in time, we are taking up space on the docket and timeframes are being waived by us, but is it necessary? Is this point in time, is it necessary? And I don't think that it is. I think the court made the recommendation today and asked us to consider it because everything that is already in place would allow for those questions that are left yet unanswered to be answered in the timeframe that they are able to be. If the court is not so inclined to dismiss this case today, we would ask that the, and there was no objection earlier, that the trial that is scheduled for February be moved to perhaps have a settlement conference after, in this case, maybe in May, or if we can set dates for later this summer. I certainly don't want to take up 3 days on your docket if we don't need to. However, I also want to ensure that we are able to utilize any and all witnesses in any and all testimony that may come out of those other proceedings. So if you're not inclined to dismiss today, we would ask for a move and adjournment of that jury trial, and we would waive any and all timeframes as it relates to hearing this petition as we had previously.
Ms. Weiss.
Your Honor, I would just ask you to set a 6-month review.
The court finds all interested parties are given notice for purposes of today's pretrial review. I have reviewed the information, I've listened to the testimony of the witnesses, and for purposes of services that could be utilized by the family, and to justify the further intervention of the court and the Department of Health and Human Services under the circumstances, I'm willing to grant another review period, but so essentially I'm going to reset our pretrial to be another review in, frankly, we're going to reschedule the jury trial, not reschedule it. I'm taking the jury trial off of the docket for February 12th through the 14th. I'm setting another pretrial review at 10 a.m. on February 14th. You should all still be available at that date and time, given that you should have had that on your docket already or your schedule. And that is to allow Mr. Farian some time to look into the recommendations that were made in the trauma recommendations or the trauma assessments for the children, including that OT referral, that trauma class referral that could be utilized through DHHS, CMH. But frankly, that's the only real benefit that I can see at this time. I have serious concerns allowing the department to continue to have this petition pending after February, so I will signal that to you at this point, because the case was filed June 21st, 2023. The case would have to be heard on the allegations in the initial petition. Obviously, we are having reviews that are monitoring services that are in place for the children. So the risk of harm, the underlying facts of the petition clearly would still be relevant, but the remedial actions that may have been taken by family members, criminal courts, or even Mr. Mulholland himself, could be significantly different by June of 2024. So it would be, I think, extraordinarily difficult to proceed on a petition that's a year old at that point, given those changes. And the department would likely minimum have to file some kind of amended petition to reflect what's happened during that period of time. So otherwise, I frankly, if I didn't have these outstanding issues that need to be addressed, out of the recommendations for the trauma assessments, I would be inclined to dismiss the case today. The bond conditions do prevent Mr. Mulholland from having any contact with his children. There is case law out there that supports that that is security against a risk of harm to a child under the circumstances. And the services that are in place, that counseling is already taking place under a private pay insurance platform. So I can't see justifying the department time and expenses and the court's time other than to allow for those continued referrals. So in the meantime, you can continue to monitor the criminal case for purposes of monitoring bond conditions. But other than that, I'll be raising the issue of whether or not there is a risk of harm to the children in our next year. So I will see you all on Wednesday, the 14th of February at 10 a.m. for an additional pretrial review to issue a pretrial order and to check on those services and referrals that need to be made out of that trauma assessment. The children are placed with their mother. The father's not allowed to have any contact in the bond conditions as it is right now. There's no risk of harm to these children under the circumstances. So they're in the safest and least restrictive household outside of any measures that this court could even take at this point. Nevertheless, that is serving their best interests. And Ms. Instagram, you will have the opportunity in the next few months to supply any additional information about what your client might be doing, which obviously could also impact what happens moving forward in the event that his criminal case resolves itself one way or the other. So unless there's any questions, that's all for today. We'll see you
Your Honor,
again
will
on
you
the
please
14th.
continue my subpoenas?
What?
Will you please continue my subpoena at least to the 14th?
I'm not going to continue your subpoena. Much of the testimony that I heard from Ms. Abbott today was not relevant for our purposes today. I wish you the best of luck in your criminal case adventures on that point. But if there's something specific you want us to hear from Ms. Abbott in the future, I would like to certainly see that, and she would need to have advice on it. But as of right now, I don't see any reason to do that. Any other questions?
No, Your Honor.